My name is Lise Alm, and I am Head of Business Development at the Arbitration Institute of the Stockholm Chamber of Commerce. And I will start with the challenging first task of trying to share my slides. So let me see if I can manage. Let's see here. Okay, so hopefully you're seeing my slides now, and I trust that one of the organizers will let me know if that's not the case. So no, I'm not. Hold on, because there is another button to press. Am I better off now?
Yeah, we can see it now.
Well, there we go. Okay, perfect. Thank you. I gotta say first that it's a bit daunting always to go out quite late in a summit like this, because there's been so many really brilliant speakers before me that I am a little bit humbled and intimidated right now, but I hope that I will be able to stand tall here with the rest of them and talk about this brilliant new world that I'm hoping that we're seeing. So to begin with, as I said, I'm from the Arbitration Institute of the Stockholm Chamber of Commerce, or the SEC for short. It's one of the world's biggest arbitral institutions, and we administer hundreds of cases from all over the world every year. So I'm a lawyer by training, but I've spent most of my career in tech companies such as Spotify and others. And the last few years, I've moved entirely over into trying to develop the field of law, and specifically arbitration. So my role at the SSC is trying to predict where our industry is going, figure out what dispute resolution will or should look like in the future, and how we best get there. Now, in practice, on a day-to-day basis, I'm often busy implementing those blinged-up SharePoint technologies that, for instance, Hussein Hadi talked about earlier today. But some days, I get to look up from the back end of our own digital transformation and look at the bigger picture. Those are really good days, and today is one of those days. So naturally, when I do this, one of the areas that I'm looking at with a lot of curiosity is AI, and how that will affect arbitration. And that is what I will be talking about today. So first of all, AI in arbitration is not in the future, because we already have that here. So to just kind of mount down that a little bit, you can talk about, when you talk about AI in arbitration, you don't have to look into the future. You can talk about things that are already going on right now. Processes that are today being fueled by AI or machine learning technology or other sophisticated technology right now. And that will be even more automated in the future. These are changes that may seem controversial at first, but when you look at them closer, they might not be more controversial than replacing the fax with emails or the telephone with video. So this could be, for instance, automated document review or document production, various platforms that support or help find relevant cases or information, intelligent natural language detection used for transcription or translation, and so on and so forth. And the speakers here today has given a plethora of inspiring examples of things that are going on right now. So, as I said, these exist today, and as they gain more traction, they will have the opportunity to change the way our industry works in an equally profound way as email or the internet did when it came, i.e., it will become the norm, a ubiquitous, effective way of doing things, essentially the same things as we are today, only faster and arguably better. And there's a lot to say about these things, and I could easily spend the rest of this presentation talking about them. But today I won't. Today I want to look further into the future, and I want to talk about whether or not we can and should go the full mile. And in that, I'm talking about whether or not we should aim to replace human arbitrators or judges with robots, with AI arbitrators. So when you read about the intersection of AI and the judiciary, the vision you get vary from, on the one side, the notion that lawyers and judges and what they do is so unique, so magical, and so quintessentially human that no machine can ever replace even parts of what they do. On the other side, you have the vision of an omnipotent, universally fair, super intelligent AI judge. Someone or something with instant access to all relevant facts, all legislation, all case law, all doctrine, everything, ready to rule in seconds, an instant judge in your pocket. Now, obviously, neither of these are true. Bit by bit, arbitrators and judges will be more and more fueled by technology and AI, just as they already are. You don't see many arbitrators writing their awards on a typewriter or communicating via paper and goose pen, nor for that matter, assessing a full case without looking something up using AI-fueled search engines or databases like Google, or assessing evidence without technical enhancement in any way, or managing their cases without some sort of digital platform. So this is we're already technically enhanced today. And the use of sophisticated technology is increasing gradually and often without many raised eyebrows. Over time, without us necessarily noticing it, this type of technology will take over and likely happen to a much larger degree than what we might think today. Just think about the fact that in 2007, we didn't have smartphones or streaming technology was still being developed and so forth. So that just shows how much something that was entirely new is a ubiquitous norm today. So going further here, if you look at back in 1965, Gordon Moore gave a statement which later translated into something called Moore's law. It is quite simplified, tells us that the computing capacity of computers will double every 2 years. As you can see from this graph here, it actually talks about transistors, but effectively we are talking about computing power, the ability to process data. This is still holding true today. If this continues to hold true, in 2050, a computer will have the same computing power as all human brains combined. Now, I hope that we will be leveraging this type of power also to improve the judicial processes, because they do need some improvement. Does that translate into an AI judge ready to rule on everything in seconds? Well, not really. So let me put it out there to start with. Human judges will not be replaced by AI judges anytime soon. As I'm sure many of the people listening today knows already, if you scratch the surface of AI just a little bit, it doesn't really work quite that simple, that as long as you have a big enough computer, it'll all work out. So instead, we're quite far today from a machine that could rule on all cases, similarly to what a human can. That said, though, AI is being used in court systems all over the world today. So as you can see from some of these examples, we have sophisticated examples in China, in Estonia, in Latin America, in Canada, and so on and so forth. Many of these have been touched upon by the presenters earlier today. One thing in common with the examples that I bring up here is that they're all relating to court rather than arbitration. There are reasons why this is easier in national courts than in arbitration, and this relates both to the dynamics of how innovation in the arbitration works, which I will refrain from jumping into that pool today, but it also pertains to the access to data in arbitration, which I will come back to. But sophisticated and predictive technology is sipping into arbitration as well already. You may want to check out, for instance, a company called Arbitration. That is one really interesting example. Arbitration is an American company using predictive analysis to predict outcome of cases. And they have a 91.8 accuracy in their predictions when when they're saying this case will probably land like this. And I doubt many human judges would come close to that result. So using predictive AI could be a great way to tackle some of the issues that we have in the judicial world today, but it's not entirely uncomplicated. So I wanted to take a closer look at how AI works, and especially how that affects if you were to put it into use for predictive analysis within arbitration, essentially for rendering awards. So to begin with, as I'm sure most of you know, an AI system today is programmed for a specific task, like ruling on a specific type of cases. And then it solves that case then it learns how to solve that case through training on and adapting to real-life data, like previous similar cases and circumstances. Sorry, there we go. So how AI systems are created and programmed is a chapter in of itself, but for today, I will focus on the data aspect here. As you may know, arbitration cases are by default confidential. In a normal commercial dispute, those that have access to the data are the parties and the counsel, the arbitrators and the arbitration institutes, like the SEC that I represent. Out of those, the one that have access to at least some volume here in terms of cases are the institutions. Now, providing access to the data that we sit on from a confidentiality perspective is a bit tricky, but it's certainly not impossible. And I believe there are ways to use our data as anonymized training data for AI without breaking confidentiality. We're not very good at doing this today, I admit, and I stand here as one of the institutions that are not great at doing this yet. So I think that one of the tasks that we need to take upon ourselves is to actually do this better, to collaborate with the people providing technology here to give access to training data in a good way. So the issue of access to data is one of the reasons why the solutions that you do see here are in the area of investor-state dispute, which is where a state is involved and often therefore the award become public. The example I gave before, Arbilex, is one of those. They're training on publicly accessible data. So this is one of the biggest challenge that you have, or one big challenge that you have for AI and arbitration. The next challenge you have has been touched upon already today by several other speakers, and that is about bias in the data. So, I mean, say that we solve the access to data. The obvious issue with learning from real life data is that real life is not perfect. The classic example is that the data may contain human prejudice, such as racism, and the AI might draw the conclusion that it seems that darker people are more likely to be sentenced and therefore add skin color as a factor when deciding on a case. This is naturally not great, but when the issues in the data are predictable, however tragic that fact in of itself is, it means that it's possible to find it and to compensate for it. You can tell a computer to ignore skin color, and by and large, it will. It's naturally a lot more complicated than that, since bias in practice is not just a matter of one factor in a person. But as was discussed by, for instance, Christina Blacklaw earlier today, this field is being worked on, and there are various ways to try and address getting fair data as training data. So that brings us to the next step. Say that we have access to perfect or, well, unbiased data. Then we come to the issue of causation and correlation. Now, causation is when something is causing something else, and correlation is something that just happened to happen alongside something else. And this distinction is extremely important within law, but AI is struggling to make it. So I want to show you one of my absolute favorite slides of all time, which is this one. So this wonderful slide shows us that the per capita cheese consumption has a very high correlation with the number of people who died by becoming tangled up in their bed sheets. Now, I don't know much about cheese, but I'm fairly certain that the cheese didn't cause the death here, or for that matter, that the death caused a higher degree of cheese consumption, but rather what you're looking at here is a correlation, something that just happened to coincide. And for us, this would be evident that we should ignore this correlation. But for AI, the difference between correlation and causation is not as evident as it is for people. And now this specific one might not trip any AI judge up anytime soon, because I'm not entirely sure when this would become relevant. But it is still an issue that it's harder for to know which one it's looking at. And to take another, this is sometimes referred as the black box problem. And to take another example, there was a study done at the University of California where they trained a system on seeing the difference between huskies and wolves. Now, this is really hard for a computer. if you try yourself to explain it to a toddler, you'll see just how hard it is. Now, the system gave really good results, but some quite odd ones. And when they examined it closer, it turned out that all the training images of wolves had snow in the backgrounds and the huskies did not. So the computer concluded that wolves, those are the four-legged hairy creatures that have white background, and huskies are the ones that doesn't. And for optimal confusion, in my example here, it's actually the other way around, but that's besides the point. If you apply this to the judicial system, you could get the result that a car can only be parked illegally if it's sunny, or this could only be a contractual breach if it happened on a Tuesday. Naturally, the flawed conclusion would in reality be much more subtle and harder to detect for. But if we were to start applying this blindly to the judicial process, it would come with huge risks. The way that we solve for this, for the risk of bias and these type of issues in the human judiciary process, well, to the extent that we do, is by providing reasoning to the rulings. If you were to get just a blind result, just that yes, you are you're obliged to pay this amount of damages to your counterparty, or yes, you are guilty, without any of the reasoning, we wouldn't accept it. There are methods in AI that's called explained AI, which is trying to do the same thing, which is trying to overcome the hurdles of what I just explained, so that the result that is being spit out by AI is not entirely blind, but you can actually see the underlying reasoning, well, if you're a human expert in this field. So this is one area that I'm really excited about that could lead to some of the issues in predictive AI being lessened. But all in all, what we're looking at today is that AI lacks the transparency and the predictability that we would normally want to see in the judiciary. We don't really know how, and we don't really know why it comes to the conclusion it does. Now, that's not very satisfactory in a judicial system. So does that mean that we shouldn't use AI in this context? That we should try and stop it until it's more secure, or that we should make sure that it needs to be at human intelligence level and completely safed up before we use it for anything sensitive? Now, I'm a lawyer, so I'm by nature risk averse, and I might jump to that conclusion. But to begin with, we can't. This is happening now. Whether we approve of it or not, it's not happening overnight. And as I mentioned when we set out, it's already happening in smaller, less sensitive areas. So the fact that I don't think that those areas are very controversial, it doesn't mean that it doesn't raise questions. As with any shift in technology, before the technology becomes ubiquitous, before everyone has it, like with email, it will affect the balance between those that have it and those that don't. It would create an inequity of arms between those fueled by sophisticated tech and those without. Imagine if you would have to go up against a counterparty using email back in the days, and you would only be able to get organized using pen and paper. Now, in the future, if you go up against somebody who is fueled by AI and you only have the technology that you're using today, then that will create for a great imbalance. So to give you an example of one case, there's a case coming out of the Netherlands where it was an appeal based on the one of the many grounds for the appeal, or for the challenge rather, was that they thought that too much of the award was written by one of the arbitrators. The way that they arrived at that conclusion was that they used natural language analysis to analyze who wrote what. This would have been really hard if you only had human analysis capabilities, but with AI, you were able to do a much deeper analysis of this. So if you then need to counter that argument and you don't have access to AI, this is really hard. So when this gradual shift is coming, it's really good that it is gradual and we have time to save up the technology, but it will also create this unbalance as it is growing out. Now, the other aspect is that, in terms of whether we should be promoting this or not, is that we very much should be promoting this. We have a system today that is far from perfect. And often when you talk about technology coming or not, you're saying, is this a perfect technology? Should we use it or not? But you don't really contrast it to what you have today. Do we have a perfect system today? And I would argue that we don't. We are struggling with lack of access to justice. If you talk, according to the OECD, every other person in the world lacks access to justice. And if I refer back to Mark Beard's presentation earlier today, only 5% of those with a legal problem that is severe enough to keep them up at night choose to go to the courts. Now that indicates a pretty severe issue to me. And if you do go to court, we have the issues of human bias, of corruption, and so on and so forth. So I would say that we have a moral obligation to try to mitigate those challenges with the strongest tools that we can find. And some of those tools include AI. So for me, I think definitely we should be using this to as much an extent as possible and as responsible. Lastly, there are ways to mitigate the risks of AI. So as I explained, there's a ton of work being done in this area, with both engineers and practitioners and policymakers all have really important roles to play in this. The technology is naturally not necessarily quite as stupid as I gave the examples before. And there is a strong movement towards explained AI, towards fairer data, and towards having, I'm sorry, I'm losing my thread. And other various ways to address the black box problem. And the other thing here, as I mentioned, since this isn't happening overnight, we will have time to adopt this responsibly and implement relevant safeguards along the way here. When we do this, there's one thing that I wanted to use as an inspiration for us, and that is the way that we talk about automation levels in self-driving cars. So this is a 6 steps of automation levels brought out by the Society of Automotive Engineers. And what this essentially means is that in the initial stages, the AI is all about enhancing the human while keeping her in full control. These are things like warning systems if she's falling asleep, drifting off the road, and so forth. Now, these are undoubtedly positive changes, and they have very few concerns. However, if it comes to full driving cars with no human involvement, now that's instead a great deal of concern. And when we adopt AI in the judiciary system, it will be the same. The first aspects are about removing repetitive tasks, simplifying searches for relevant information, etc. And it's generally all good and not that complicated. Replacing arbitrator or judges with robots without having any human supervision is arguably a very bad idea today. So to sum up, what we have, AI is already being used in arbitration today in various areas. AI-fueled judges are the future, and that is a good thing. Access to and quality of data and transparency are issues for using AI in arbitration, but there are ways to mitigate them. And as lawyers, we play a really important role in getting this right. So having lost slightly track of time, I wanted to say thank you and see if there are any questions for me.
Thank you so much, Lise. Yeah, I think we had one or two questions. So one of them was, given that there's a lot of data in the public domain about arbitration results, can Arbilex use this to enhance their already great accuracy?
Well, to my understanding, they have already. So Arbilex is focusing on the world of investor disputes. So these are the big cases where you have a state on one side and you have some sort of investor on the other side. These most often become public, and I believe that they have a database of 1,600 or so cases. So they are already using this, and I know that they are interested in using it also for commercial cases, but they don't have the data available today. So I would refer the question to them, but generally I say that you might not have enough data outside of investor state that is public today. Another benefit of using it for investor state data is that you have a finite number of issues that come up. If you take all of commercial disputes, you have a wide plethora of different issues that you may need to address, leading to you needing even more data. Whereas if you pick one area, such as investor state, then you can get by with less data. But I would imagine that that number that I mentioned, 91.8%, is going to go up over time, definitely.
Okay. Thank you so much, Liz. So as you rightly pointed out, we're running a bit short of time. But thank you so much for this presentation. It was very, very interesting and stimulating, really what you said as well about policy, opening the black box, all these concepts, really, really interesting. So thanks a lot for your contribution.
Thank you. Let's see if I can stop sharing. There we go. I think I got let go of you now, right?
Yeah.
Perfect.
Exactly. Thank you so much, Liz.